All right, so let's get started. Welcome to Abortion Rights and Reproductive Justice in Latin America, recent landmark decisions from Mexico and from Colombia. We're incredibly excited to have you here today. This is an event that's been co-sponsored by the Global Health and Rights Project, GHRP, which is a collaboration between the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School, and the Global Health Education and Learning Incubator. And also co-sponsored by the David Rockefeller Center for Latin American Studies, Dr. Klass, here at Harvard University. I'm Glenn Cohen. I'm a professor here at the law school. I'm the deputy dean, and I'm also the faculty director for the Petrie-Flom Center. First, a few logistics things to tell you. We're glad you found your way to this event. If you want to keep up with other things by the Petrie-Flom Center, you can subscribe to our newsletter. There's a sign-up sheet at the registration table, and you can find it online as well. You can read our blog, Bill of Health, which gets hundreds of thousands of readers a month. There are also QR codes with links to these on the registration table as well, if that's a way you prefer to access it. I want to mention that the exits are back there. If you need to use the bathroom, it's around the corner. And today's session will have some addresses from a number of people, but we'll end with a Q&A session where people, both in the audience, will be able to ask questions and those online. If you're in the audience and you'd like to ask a question, just queue up at the microphone. I will emphasize that they should be questions, which means they should end up with a question mark and be relatively short, right, rather than diatribes. But we're hoping to have a bunch of excellent questions. I'm also going to apologize that I'm going to have to leave the event 5 minutes early to get to my classes and my office hours. But one of my colleagues is going to close the event and thank everybody, but we're incredibly lucky to have them here. I'm going to introduce a pivotal force here at Harvard behind this event, Professor Yeaman, who's a lecturer on law and senior fellow in global health and rights at the Petrie-Flom Center. She's also an adjunct lecturer on health policy and management at the Harvard T.H. Chan School of Public Health. And she is an incredibly prolific and important writer on these areas, so we are so excited to have her kick us off and do the introductions.
Thanks very much, Glenn. So I also just want to express how thrilled we are to be able to host this event, to have two sitting justices on high courts discuss landmark decisions with us, and a discussant who is one of the leading experts on abortion jurisprudence, the history of abortion jurisprudence in the United States. Really just thrilled, and hopefully this will be an uplifting event given recent given Dobbs and given the U.S. Supreme Court's actions to restrict abortion rights and reproductive justice. Now, before I hand it over to our keynote speakers, I just want to give a little bit of context, primarily for U.S. law students, which is that, the narrative of, well, the U.S. has become an outlier now among democratic countries in restricting abortion, while the three most populous countries in Latin America have suddenly taken huge leaps and bounds to liberalize abortion. And that is part of the green wave. Now, that's true, but we want to provide a little bit more context for you to understand what the speakers will then go into much more detail about. So the first thing to say is that what has happened in these three countries, and by the third one I mean Argentina, is not quite the same and doesn't present quite the same inflection point. So Argentina, which is generally noted as having started this green wave in December of 2020, passed Law 27612, which legalized abortion up to 14 weeks of pregnancy for women and persons who gestate. It also provided for access to contraception and sexuality education. At the same time, another law was passed in Argentina that was called the 1,000 Days Bill, that was really for early childhood care for children. That is a different situation from Mexico, where the Supreme Court unanimously, taking a case from Coahuila, Mexico, as is Argentina, is also a federalist state, found the absolute prohibition on abortion, absolute decriminalization was unconstitutional, unconstitutionally violated, among other things, women's reproductive autonomy rights. That decision will now mean that states in Mexico need to change their criminal codes and need to legislate and regulate the service of abortion. This year, in February 21st of this year, the Colombian Constitutional Court decriminalized abortion through 24 weeks in a much closer decision, 5-4, in a very contested decision after some delays. And that decision, too, will need to be, the political organs of government will then now need to take it over, pass legislation for financing and policies, and you'll hear much more about that. The second thing to say is that the idea that this just happened in the last few years is also not quite right. Feminists in Latin America have been pushing for abortion rights really since the 1970s, when feminists around the world began pushing for abortion rights. But certainly, I had the privilege decades ago in the 90s of working in Mexico with Marta Lamas, who is sort of one of the pioneering feminists of the region. And when I was all gung-ho and eager for quick change, she said, this is a marathon, not a sprint. And that has proven to be true. In Colombia, actually one of our Global Health and Rights Project fellows has just written a really interesting article, published a really interesting article on the role of feminists in the Constituent Assembly that led to an iconic 1991 Constitution. And they have been pushing iteratively, both on the political organs of government and the use of courts. And in Argentina, certainly this has been an issue on the agenda of feminists in the country since the return to democracy in late 1983, iteratively building out a national campaign that was established in 2005, making it less of a dissident perspective, focusing on abortion restrictions as structural violence against women that then was synergistically connected to other movements against violence against women and femicide, which happens to be quite prevalent in many of these countries. So that all really highlighted and brought to the surface in the last few years what has happened. And we'll also hear about social movements working together across the continent. And I guess the third thing to say, because we were just asked a question about this when we met with Dean Manning, is that the universe of norms on which the courts draw is quite different from the United States. So this is not a cut and paste situation. The United States has maybe the archetypical, traditionally liberal constitution with an anti-democratic organization of power, as we've heard, but also a very austere set of rights that it recognizes. Whereas in all three of these countries, Argentina, Colombia, and Mexico, that is not true. There are much more robust social contracts that include enumerations of economic and social rights, and social contracts of social states of law or of democratic states of law, where, for example, equality is not a measure of sort of formalistic equal protection, but much more substantive equality, as in people come from different starting places and have different needs to effectively enjoy, say, health rights. And that has also been inflected by the incorporation of international human rights law into domestic constitutions, which is something that we don't do very much of here, even though we have formally a monist system. But that incorporation of international human rights law, as my students will be tired of hearing me say, doesn't mean that some treaty monitoring body is going to say abortion needs to be accessible XYZ under these criteria. It is not that kind of mechanical application, but it does mean that the conversation is broadened, that how the scope and content of rights and how the balancing is done among rights takes on board a broader set of conversations and institutional reference points, including if the Inter-American Court says, there is that fetuses do not have personhood. That is absolutely relevant, if not persuasive in every case. And the last final thing I'll say, since we're at a law school, is that this didn't happen automatically, right? So part of the difference after having enacted these much more robust, social, transformative, whatever you want to call them, constitutions, that required a different approach to adjudication and judging. And that doesn't happen automatically. Some of it is informed when judges, as our two speakers, come and get LLMs at Harvard. Some had to go to Yale or Chicago or elsewhere, but that has helped. But it's also true that there was a whole network of feminist law professors that began in Latin America, called the Red Alas, which really deliberately and purposively started to change the pedagogy of how law is taught, and really looking and sharing strategies and information about these kinds of cases, and that has proven to be absolutely influential. So, for example, changing the criminalization frame to one in which exceptions are not just exceptions to criminalization, but spaces in which you assert your rights. That change in conception was very deliberately brought about by concerted strategies of feminist law professors working over time. And with that, I think that's some of the context. I am absolutely delighted to introduce our first speaker, Justice Alfredo Gutierrez Ortiz Mena, who is a justice at the Mexican Supreme Court. He is a graduate of the UNAM, the National Autonomous University of Mexico, as well as having a Harvard LLM. Between 1995 and 2012, Justice Gutierrez Ortiz Mena worked for different international law firms. He then served as Minister of Finance and was appointed in the Ministry of Finance, and he was appointed by the President of Mexico as Commissioner of their version of the IRS from 2008 to 2012. In November of 2012, he was nominated by the President of Mexico to fill a vacancy on the Supreme Court, and I think is the youngest justice to have been appointed in history. And his approach is one that is, considered a very liberal and progressive approach, and he has written some important judgments specifically on abortion. In fact, he spoke just a few years ago before the pandemic on the state of abortion jurisprudence in Mexico at the time. Justice Gutierrez.
Well, thank you very much. It's a pleasure to be here. I want to thank the Harvard Law School, the Petrie-Flom Center, Glenn, Alicia, thank you very much for making this happen. Carmel, thank you for all your support. I also want to say it's an absolute honor to be here and share today's panel with Justice Natalia Angel Cabo from the Colombian Constitutional Court. It's truly an honor to be here with you today. That said, let me begin my talk today. And what I want to do, and Alicia pretty much stole all my thunder, because I want to do a sort of like a purview of what has happened in the last 20 years in Mexican jurisprudence with relation to abortion, because it didn't happen overnight. The rulings we had on September of 2021 have a long history, and And it's been a very, very, very long, long road to where we got to last year. So I would like to put it in context, because a lot of it also has to do with how Mexican democracy has evolved in the last 20 years. So it's important, I think, to put these decisions in context and see where the decisions were built upon over the years. As most of you know, Mexico is a federation. We have 32 states. Criminal law in Mexico is a state issue. And regrettably, when we talk about abortion, we have to start with criminal law and criminal law in Mexico. So that will be my starting point with this conversation. I think the starting point, or what really got Mexico discussing abortion and discussing abortion rights, has to do with the state of Baja California, it has to do with Mexicali, and it has to do with a very progressive Mexico City. First of all, with Baja California. The year is about 1999, and there's the caso Paulina. In this case, there was a 13-year-old girl who had been raped, and according to local criminal law, in order to get an abortion, she had to get the district attorney to sign off on the procedure. And Paulina and her mother got the district attorney to sign off on the procedure. Unfortunately, the situation didn't end there. The Baja California Attorney General visited Paulina and visited Paulina's mother and took them to a priest. And the priest explained to Paulina and Paulina's mother that if she got the procedure, she would be excommunicated from the church. This did not dissuade Paulina from getting the medical procedure, and she went to the general hospital in Mexicali, which is the capital of Baja California. Upon her arrival, she was greeted by the director of the general hospital. And the director of the general hospital misinformed Paulina about the risks to her health and the probability of her dying from the procedure. Again, this did not end up dissuading Paulina, and she entered the hospital to get the procedure. And while she was in her room, an NGO, a pro-life NGO, entered her room and proceeded to show her photographs and videos of fetuses and of aborted fetuses. Needless to say, Paulina did not get an abortion, and on April 2000, she gave birth at 13 years of age. This was an outrage, and Mexico City, which has a tradition of very progressive legislation, started to change its laws on abortion. And the first law was called the Ley Robles, about that time. And the Ley Robles, basically, what it did was expand, I would say, justifiable defenses on a statutory level in order to avoid criminal conviction of abortions. And the new justifiable defense was health. It had for rape, and now it had for health. And the curious thing, and I want to put an emphasis on this because it's important down the road as I continue with this historical narrative, the federal attorney general and the Federal Human Rights Commission challenged the reform in Mexico City. They were against increasing the types of defenses against criminalization or criminal convictions of abortion. The case went to the court, and the court decided the case in favor of upholding the law, but it was upheld, and this is very important, on a statutory basis. There was no discussion as to a woman's constitutional right. This was simply whether states could increase the causes for justifiable defenses in criminal cases against abortion. So the court very narrowly on a statutory issue decided the case. We can fast forward now to 2007. 2007, again, Mexico City, with its very progressive legislation, decides to decriminalize abortion. And it decriminalizes abortion for the first 12 weeks. Again, the Attorney General, the Federal Attorney General, and the Federal Commission of Human Rights challenges the decriminalization of abortion. And here, let me give you a little context as to how cases get decided in the Mexican Supreme Court, how cases get to the Mexican Supreme Court, and a little context about the changes that had happened with the Mexican Supreme Court, because I think it's important to understand this decision, especially this decision. Cases can get to the Supreme Court in Mexico 5 ways. First, where you have circuit court decisions which are contradictory, the court will decide between the 2 circuit court decisions. Second, we can grant cert, like in the US. Third, there is a special appeal when circuit court is deciding a case and there is a novel constitutional issue. The case can be appealed to the Supreme Court, and the Supreme Court will decide on a very narrow basis that constitutional issue, and then the case will go back to the circuit court for final adjudication. The next 2 are more European and less US type of challenges. The first one is where there is a conflict between federal and state, where there's a federal and state issue. States or the Federation can come and argue that there has been an encroachment on their jurisdiction, and the Supreme Court will decide that issue, or where there is encroachment between the different federal powers, legislature, executive, and then the court will decide. And the 5th and final is when we can decide on the constitutionality of a law on an abstract basis without case or controversy. But the important thing here is citizens do not have standing for this type of challenge. This challenge has to be brought either by certain governmental entities. Now it's a Solicitor General, but before it was the Attorney General, the Federal Commission on Human Rights, or a minority in Congress that's challenging a law that has just been enacted. And the court will adjudicate on the constitutionality of that law without a case or controversy. And these are the cases that we're getting to the court on abortion. They had nothing to do with women seeking to assert a constitutional right. They were, at this time, abstract challenges to the constitutionality of the law being pursued by the Attorney General, the Federal Attorney General, or the Human Rights Commission. And they were challenging them in order to preserve the criminality of abortion in the Mexican states. So Mexico City, with that context, Mexico City decriminalizes abortion in 2007. The case comes to the court on an abstract challenge by the Federal Attorney General and the Human Rights Commission, and they argue against the decriminalization of abortion. Another little point of context that I want to give you. At this time, the Supreme Court had been reformed, a major reform in 1994, which basically created a constitutional court in Mexico for the first time. After 70 years of one-party rule in 2000, we had for the first time, an opposition candidate win the presidential elections. So we were starting on our road to democracy. And in this context, I would say the court at that time was primarily preoccupied with establishing or setting the limits on executive privilege, on legislative boundaries, state, federal issues. there was very little interest in the court at that time with civil liberties issues. It was much more, if you look at the decisions that were taken from 2000 until about 2010, most of the decisions were adjudicating between federal-state issues or encroachment by the executive on the legislature or vice versa. Very little was said with regards to civil liberties or human rights at this time. So what did the court do? The court clearly wanted to preserve the Mexico City legislation. It went to its toolbox and it said, this is a state issue. And because it's a state issue, Mexico City can decriminalize abortion. Now, this had unintended consequences. Right after this decision, 20 of the 32 states amended their constitution to include fetus personhood statutes in their constitutions. That was the direct result of this ruling. And it was a decision meant to protect Mexico City legislation using the toolbox that the Supreme Court was using, which was at that time, really it was just adjudicating state-federal issues, and it had this unintended consequence. Let me fast forward to 2011, and this is something that Alicia already mentioned. 2011 was very important in constitutional terms in Mexico because we had a huge, huge human rights amendment. Basically, what we did, we modified Article 1 of the Constitution, and Article 1 incorporated automatically all the human rights that are in any treaty to which Mexico is a part. Human rights, treaty human rights for which Mexico is a part are now part of the Mexican Constitution. So this opened the floodgates. A Supreme Court that was not preoccupied with civil liberties suddenly became very preoccupied with civil liberties, very preoccupied with adjudicating human rights in concrete cases, not in abstract cases. And there also came a changing of the guard at the Supreme Court. New justices, we have 15-year term limits, started coming to the court with a different view of what the role of the court was in this new democracy. It was no longer just adjudicating between federal and state issues or between executive encroachment on the legislature, but there was a very, very, very open intention to start discussing civil liberties in Mexico. And with this context, we start seeing amparos. And amparos are the way individuals can adjudicate their rights. As I mentioned before, the previous cases were all acciones de inconstitucionalidad, where the court was deciding cases on an abstract level. Who has standing in those cases? Governmental entities or the legislature. Who has standing in amparos? Individuals. So for the first time, you start seeing amparos where individuals, women, are starting to assert their rights in court on a constitutional basis. And the discussion now changes. The discussion now in the court isn't a statutory discussion about justification defenses in criminal convictions. It's about whether women have constitutional rights. And that is a whole other dynamic that's an entirely different language. We went from statutory decisions to constitutional decisions. We went from justification defenses to asserting the right to reproductive self-determination of women. Now, the first cases are very narrow, as you would expect in any constitutional court. The first two cases, I would say, were two cases that had to do with rape. And the doctors had refused to do the procedures, the medical procedures. And the case got to the court. The court said the doctors had violated the human rights of the two women. There were reparations involved as a result of the adjudication of these two cases by the Supreme Court. But the Supreme Court said two things. First, women had a constitutional right to live without violence. And the fact that the doctors had not performed the abortions was an act of violence. And secondly, the court asserted an affirmative duty by public hospitals to perform and give free access for abortion, safe and free access to abortion. So now the language has changed. We are now speaking about constitutional rights. We are not speaking about women's rights. We have abandoned as a court the discussion of statutory determinations or defenses. Then we fast forward to 2018, and this case is not a rape case. This case is a case about health and health law and the right to health. I had the privilege of drafting this opinion with an extraordinary group of law clerks. And this case, it was a high-risk pregnancy. Margarita was 41 years old, and she was overweight, and she had two visits to the hospital because she was having what appeared to be spontaneous abortions. The fetus was diagnosed with Klinefelter syndrome, which was not, it would not affect the viability of the fetus. And she repeatedly requested an abortion at a public health clinic. There were several verbal requests for an abortion, and there was a written request on an abortion, which she received a written reply denying her access to abortion. She went to a private clinic and got the abortion in the private clinic. She sued, and the case got to the trial court, and the trial court declared the case moot because she had already gotten an abortion. The case fortunately worked its way up to the Supreme Court, and the Supreme Court reversed the trial court decision. And the reason why it wasn't moot was because the court took a stance where it took health law and it translated it into well-being. And well-being is physical, it's mental, and it's social. And it said it is not moot because abortion is the beginning of the healing process, not the end. And the fact that a woman, because of her reproductive organs, is denied access to court is discriminatory in and of itself. And for the first time, the court asserted a constitutional right to reproductive self-determination. So here we are, 2018. We're abandoning statutory discussions. We're asserting the right of a woman on a constitutional level, first on very narrowly in rape cases, and now we're taking the right to health and expanding it into a right to well-being in a much, much broader context. And if you would have asked me back then, I would have said the discussion is over. Fortunately, it wasn't. Before I get to the September cases, there was one other case which was very important, and it had to do with when the time limits for getting an abortion. This was a young girl who had a severe mental illness and could not speak, and she began to have spontaneous convulsions. Obviously, the parents were unable to determine what the spontaneous convulsions were, or what was causing the spontaneous convulsions. And it wasn't until the 23rd week of gestation that they realized she was pregnant, and obviously she had been raped. The law in the state of Chiapas, which is in the state in southern Mexico, allows for abortion in cases up to 12 weeks of gestation. The court took the case, and the court decided that continuing the pregnancy was a form of torture. It said it in its adjudication, and it declared unconstitutional the term limit of 12 weeks for narrowly tailored it for rape and severe economic duress. This brings us to the two cases in September of 2021. And these were very, very important cases. As Alicia mentioned, they were unanimous decisions by the Supreme Court. And I think they really paint a picture of how much things have changed in this area. The first issue was whether criminalizing abortion violated the federal Constitution. States have jurisdiction on criminal matters, criminal codification, and the issue here was, could they criminalize abortion? This is a huge, huge change from 2007, where the court was saying it's a state issue. So the constitutional challenge, ironically, was brought by the Federal Attorney General's Office and the Human Rights Commission. This time, arguing that states could not criminalize abortion. These were the same institutions that 10 years before were fighting tooth and nail to maintain criminal statutes on the books for abortion. As I said, the decision was unanimous. States could not criminalize abortion without violating the federal Constitution. The court retook a lot of the analysis and a lot of the discussion it had on the health and the rape cases, and it basically said criminalizing abortion is unconstitutional. Reproductive self-determination is a constitutional right. Access to abortion is a constitutional right. Free, safe access to abortion is a constitutional right. The rights are grounded on a woman's right to privacy, on a woman's right to health, and the right to live free of violence and discrimination. These had already been built, or the court had already adjudicated cases narrowly tailored on these issues, but it had never confronted the issue of whether the states could criminalize abortion. The right to privacy, the right to be left alone was not enough. The state has an affirmative duty to provide safe access to an abortion. The court did say the fetus does have a constitutional protection, but it is incremental as the pregnancy moves along. And finally, the second set of cases that were decided in September of 2001, again, I had the privilege of drafting these opinions with a superb group of law clerks, and it was discussed whether fetus personhood laws on a state level were constitutional. And again, a unanimous decision by the Mexican Supreme Court. They were deemed unconstitutional. And basically, the Supreme Court retook the same analysis, the same discussion, and reaffirmed the same rights that had been just adjudicated in the previous case about decriminalizing abortion. And that, in a nutshell, is a 20-year history of jurisprudential evolution by the Mexico Supreme Court. Thank you very much.
So now I'd like to invite Justice Natalia Angel Cabo, who is a justice of the Colombian Constitutional Court. To be clear, she was not on the court when they issued the judgment on February 21st of 2022. Justice Angel Cabo is a graduate of the Universidad de los Andes. She also has an LLM from Harvard Law School and a PhD from Osgood Hall at York University. Before joining the court, Justice Angel Cabo was a professor of law at the Universidad de los Andes Faculty of Law. She also served as director of the support office to the Constitutional Court in its special follow-up of a huge, major structural judgment on internally displaced people. She has served as editor of the Latin American Law Review and was founder and director of the Program on Equality and Social Inclusion, PAIS. She has been a consultant to many national and international organizations, the Inter-American Court, the World Bank, the UN, the Inter-American Development Bank, and she focuses her academic and consultancy work, before she was obviously on the court, at the intersection of law and society, and explores socio-legal approaches to the rule of law in contemporary challenges. We're delighted and honored to welcome Justice Angel Cabo.
Thank you, Alicia, and thank you, Glenn. I'm really honored to be here and sharing this panel with Justice Alfredo Gutierrez and with Professor Mary Siegel, which is there, and I'm a huge admirer. I'm also thrilled to be back in Harvard. It was the happiest time of my life in 2001 when I was here as an LLM. So I have been asked to talk about a recent judgment of the Colombian Constitutional Court that decriminalized abortion up to 24 weeks. It's judgment 55 of 22. It was just enacted in February of this year. But I will do the same as Justice Gutierrez, because in order to explain the judgment, I think it's important to provide some background. As this judgment is not an isolated ruling. As a matter of fact, is the result of a confluence of factors. Just to name a few, the enactment of the Colombian Constitutional in 1991, which was a very important precedent for this case. Also, the creation of a constitutional court this year, basically in February as well. It's our 30th birthday of the Constitutional Court, and also changes in the strategies of the women's movement in Colombia, and more recently, the influence of the so-called green wave in Latin America. So there are many, many factors that come together in order to have the decision that we have now. So given my little time, I could spend hours in 30 years of this process. I will not go into all the details. But I will focus on two things: the Colombian court cases, but also the strategies of the women movement in reaching the courts, because it's important. So I will divide this in three moment periods. A first moment in which religious consideration took the center stage in constitutional decisions. This has been in the past 30 years. A second moment where the court abandoned religious considerations to replace them with arguments of public health. It's not in this. And a third moment that is basically the current one, where in addition to health considerations, the court takes into account other arguments such as equality and the need to understand that criminal law should be used as a last resort. So let's begin by saying that the Constitution of 91 was a crucial factor. It was enacted in Colombia, as I mentioned, in 1991. And this Constitution was a break from the past in many ways. It was not put in place by a political party who won a civil war, as were most of the Colombian other constitutions. Instead, it was a result of a democratic and, for the time, a diverse process. For the purpose of this talk, it's worth highlighting some characteristics of the new constitution. Briefly, the 1991 Constitution clearly states that Colombia is a secular state. That is a huge issue in Colombia because we are a very, very Catholic country. And basically, it changed or broke with the previous constitution that declared that Catholicism was the official religion of the country. Also, this new constitution included an extensive Bill of Rights, recognizing, among others, the right to health, autonomy, freedom of conscience, and equal protection of the laws. As I mentioned, the Constitution also created a constitutional court and expanded public actions for citizens to address constitutional matters. Different from Mexico, we have very, very open public actions, so citizens can address the court very easily, both in two ways. One is a constitutional public action that actually we have in place since 1910, which any citizen can approach the Constitutional Court asking to declare unconstitutional a piece of legislation, anyone. And the other is tutela action, which any citizen, and not citizen, any person, because it doesn't have to be a citizen, can approach judges, any judge in Colombia, claiming the protection of fundamental rights. So in Colombia, it is very easy to access the court, and this is important to understand why the women's movement started to use public actions to address the court. So as I mentioned, well, this is a court, and this is me in the court. I'm a new justice, so this is the first picture. But as I mentioned, there has been, in these 30 years since the creation of the court, different moments in the discussion on abortion. So the first one, the first period, basically was a period in which the first justices approached issues of abortion based on religious and moral grounds. So the first case was a 1994 case, Alexander Chochamandu, who was a very active plaintiff at the court in the moment, presented a constitutional public action challenging Article 3043 of the Criminal Code, that criminalized abortion with a sentence of 3 years in prison. For Chochamandu, the criminalization of abortion stood against freedom of religion and consciousness. But in March of 1994, an all-male bench and an all-women bench would not change things, and I will explain that. But that, at the time, there was an all-male bench, as you can see, basically decided the first abortion case. The court stated that criminalization of abortion was constitutional based on the premise that pregnancy resulted in a creation of a separate being from the woman whose, I quote, conservation and development could not be limited by the free will of the pregnant women. In a 6-3 decision, most of the court stood by the notion that life begins in the conception and that there is a constitutional mandate to protect it even with the use of criminal law. 3 years later, the court again was faced with the issue of abortion in its docket. This time, another man, José Eurípides Parra, I like to mention the names of the plaintiffs because they have been a huge force in the court, brought a claimant against Article 345 of the Criminal Code that imposed a 4-month to 1-year sentence for any abortion in pregnancy cases that were the result of rape and sexual violence. This time, the court, against the secular principle just enacted in the Constitution, based its ruling in religious grounds. For example, the judges quoted a papal encyclica in a judgment to uphold the constitutional of the criminalization of abortion. Among other things, the encyclica, I don't know if you know, everybody knows what a papal encyclica is, a document, a religious document, declared that women, I quote, are not the owners of the fruit of conception, and that this fruit is an independent and autonomous human being who must be protected from any violent action to end its life. At the time, however, the court decision did not came as a surprise. As a matter of fact, religious documents were, with some regularity, used by courts. However, and this is the second moment, in the first decade of the 21st century, there was a shift in the conversation about abortion in Colombia, as that we can term the second moment. This period has its roots in the shift of the strategy of the women's movement seeking to decriminalize abortion. So the women's movement in the 70s, they have a big conversation about abortion, but they basically seek decriminalization through the legislator. But in the first decade of the 21st century, so this is Monica Roa, which was like the leading actor of this strategy that is called the Lycia Project, which stands in Spanish for High Impact Litigation for Decriminalizing of Abortion in Colombia. Basically, this was the first high impact litigation in the country. So that was very, very novel at the time. And basically what they did was bringing together a lot of women organizations, but decided to litigate in front of the court, but not asking for a total decriminalization of abortion. They were strategically in basically asking only the court to decriminalize abortion in exceptional cases, which was an interesting move. They thought at the time that we being such a Catholic country, it was wiser to go one day at a time, let's say, instead of asking for the whole ban. But another interesting thing, which I think that this project was very interested in that matter, is that they, along with the strategy at the court, they had a huge media strategy to shift the conversation. So basically, they started to shift the conversation, putting it away from moral and religious grounds to start this conversation about the banning of abortion on issues of health. So put forward that we have to talk about abortion within the realm of public health. And I think they were kind of successful in changing that conversation. And as a matter of fact, they changed even the conversation within the court. So in the landmark case C-355 of 2006, this time not all male court, but there was one woman, and I think that played a role, concluded that the full ban of abortion contained in Article 122 of the Criminal Code was unconstitutional. In its decision, the court upheld the criminalization of abortion except for 3 cases, that were the ones that the Project Lycia asked, where the pregnancy first presented a risk to the health of the woman. Second, if it was the product of rape. And third, in cases where the fetus was not viable. If I'm not wrong, this was one of the first decisions in the world to uphold abortion rights on public health grounds. And we claim that, so Alicia could correct us. But in any case, the aftermath of the case, however, was not devoid of problems. So we should expect a backlash. And definitely there were many problems of implementation. As a matter of fact, in next years after the judgment, the court decided more than 12 tutela cases where providers, for women arguing that providers, doctors, and medical staff prevented women to access safe abortion under the 3 cases decriminalized by the court. Another interesting development, which I think was very problematic, is that abortion prosecution against women increased in the aftermath of the decriminalization of abortion in the 3 cases. So in a way, it was a step forward, but a step backward in other respects. So the backlash were hard. But in any case, I think that project was very, very successful in changing and shifting the conversation to rights and not moral grounds that was at the beginning, or religious ground that it was at the beginning the conversation. So basically, we have now a third moment, that is not in, well, I don't know. So our current moment. So this was Monica Roa, the leading lady, so that's why I won. So now we have the third moment that basically is what we're living now. So let's focus on the current period of the court and judgment C-055. As for the current moment, the recent ruling that decriminalized any abortion practice under a 24-week pregnancy was, as I mentioned, also the product of a litigation strategy led by many women's organizations now under the umbrella of Causa Justa, Causa Justa movement. In a recent interview, one of the leaders of Causa Justa explained that the first strategic choice they had was not to go to the court. They were basically trying to bring about the conversation again on the banning of criminalization in Colombia, and they even thought to go to the legislature for this matter, but they saw an opportunity at the moment in the court, which was interesting because the court has turned a little bit more conservative than what it used to be. So I think it was a slippery slope strategy. It could have gone both ways, and actually it was a divided case. But Causa Justa did something very, very interesting in my opinion. First of all, it gathered a lot of data. So it shifted again the conversation, but this time with evidence, which I think it provides evidence to the conversation, evidence to the court, and very seriously evidence that it was difficult not to consider. So the claim can be resumed, of the Causa Justa claim can be resumed in 4 arguments. First, Causa Justa considered that the existing of criminal law regulation abortion was the greatest obstacle keeping women and girls, particularly those in situation of vulnerability, from receiving safe abortion services under the 3 exceptions created by Judgment C-355. Criminalization, they argue, carries a stigma that makes no distinction between what the law allows and what it does not. Rather, it acts as a broad brush, affecting in multiple ways the provisions of services that are perfectly legal. So basically, they focus that this dual system of criminalization and non-criminalization in some exceptions was really problematic. Second, they claim that the law fails to ensure the availability of services in small and medium-sized cities and rural areas, and generates and perpetuates and exacerbates barriers to access for women belonging to disadvantaged and marginalized groups. As a matter of fact, it was very interesting to show that after Judgment 355, the prosecution of women occurred against very, very poor women in rural areas. So it was not that it increased for everyone, but just for the most vulnerable ones. Third, Causa Justa at the time basically argues that this dual system of criminalization and non-criminalization continues to push women who are not covered by the exceptions to seek unsafe abortion at the risk of maternal morbidity and death. And fourth, Causa Justa argue in its claimant that the Constitutional Court has the power to decriminalize abortion because of Congress' failure to act in the face of serious equality and public health problems. And that is basically most of the arguments that many plaintiffs and we, the court, also raise in order to be an active court, because definitely it's very difficult to push these things through Congress, or it has been for many times. I was an academic when Causa Justa presented this challenge to the court, Alicia, and I have to admit that I doubted that it would have been successful. Because, as I mentioned, the court was turning into a more conservative one, and because there was a strong legal debate about one issue that was not very easy to overcome. It was the question of whether there was a res judicata, or in other terms, whether it was possible for the court to study again the criminal code provision on abortion, considering that court had made a ruling about such provision in 2006. So you needed to prove that there was a different situation, that circumstances have really changed in order to address the issue in such a short time, because it was only 14 years. So, but I think Causa Justa was very, very successful in addressing that legal issue. According to the petitioners, their new action exposed new arguments that the court had not taken into consideration in the later ruling. They also said that the social situation of women had varied since 2006, as they have faced new obstacles to access the abortion through a national health system. The court, in a very split decision, 5-4, seemed to agree. And as I mentioned, I was pointing out that we had first an all-male court and then one woman. This time around, we had 4 women in the court, and only one voted in favor of decriminalizing abortion, which was kind of interesting. So basically, we're male who pushed for the decriminalization of abortion. So let's talk about, well, I'm not going to read this, but these are highlights from the judgment, and it's just a recent 400-page judgment, so this is kind of novel that you will have it in English. So basically, what the court did in judgment C-55 of 2022, so as I mentioned, it legalized abortion up to 24 weeks, and beyond that point in pregnancy, allows also the exception permitted under the 2000 ruling. In the judgment, the Constitutional Court held that the categorical prohibition of abortion violated women's right to dignity, health, reproductive rights, equality, and freedom of consciousness. It recognized that the criminal ban failed to prevent abortion and relied on punitive means despite the availability of more efficacious and less restrictive tools to vindicate the state interest in protecting gestational life. It wasn't constitutional. In paragraph after paragraph, the court pointed out constitutional problems with the ways in which the legislature had relied upon the criminal law to protect life. It then called on the country's democratic institutions to develop comprehensive policies to protect health and life beyond banning abortion. It also called on democratic institutions to adopt social policy to safeguard the dignity of women and to eliminate obstacles to women's access to abortion. I will just read some quotes of the judgment, but mainly the rationale of the judgment was based on 3 issues. First, that criminalization of abortion has failed to provide protection, even to prevent abortions. So it was not a successful measure to prevent abortion, but rather, so it did not achieve its goal, but instead was really criminalizing and even threatening the lives of women, and especially of poor women in rural areas in Colombia. So some of the things that the court says. Life is a legal interest that must be protected at all stages of development, but not necessarily with the same intensity, which was similar to what the Mexican court decided at some point. Hence, the protection of gestational life as an imperative constitutional purpose, including through criminal law, must also be gradual and incremental. Another quote, if the legislature decides to resort to criminal law to protect gestational life, its margin of configuration is more limited due to the seriousness of this type of measure and its potential to burden other constitutional guarantees. The criminalization of abortion in the categorical terms of the law under review pushes women, girls, and pregnant, capable people to seek unsafe and clandestine abortion, which creates a serious public health problem that impacts maternal mortality rates. I can send Alicia some translation of this judgment. It's 400 pages, so it's a long. But something that is important to realize is that the court also avoid to mention some things that were controversial at the time. So there was a discussion of whether there was a right to abortion in the Constitution. And so the court says we don't have to say that. So you will not see that term in the judgment. It basically bases rationale in equality grounds, in autonomy, even in the right to life, because it says it's also that women seeking abortion also have a right to life that you should protect. So what would be the aftermath? And with this, I have to give credit to the 4 dissenters because this is a conversation that is ongoing. Basically, they said that this decision relativized the concept of autonomy and the protection of the embryo's life. In their opinion, the majority decriminalized abortion, brushing off the concept of human dignity at any stage of life. And they also concluded that the court was in no position to determine the terms limits around abortion because this was an issue of the legislature. So basically, this was February 2022. And so this is the state of the current discussion on abortion. But the debate is far from over. As a matter of fact, as of today, there are 67 writs or petitions asking to annul the judgment. So the questions of whether and under what circumstances the law protects a woman's right to terminate pregnancy in Colombia are questions that will continue to confront us in the years to come. Thank you very much.
Thank you so much. So now we're really privileged to have Professor Mary Ziegler, who was a visiting professor here last year. She is also a graduate of Harvard College and Harvard Law School, and she's now at UC Davis after being at Florida State for many years. But she's really a leading legal historian on reproduction and on the history of abortion jurisprudence and healthcare in this country. So Mary, where is Mary now?
Close the PowerPoint on that one. Let's try that.
So Mary will just provide a few comments on the 2 presentations we've just heard, and then we'll open it up for a moderated discussion.
Yes. Okay, great. So I think the question of what didn't happen here or what changed in the United States, because as Alicia flagged, I think the United States is an outlier in terms of the trends we're seeing. And I only have 10 minutes, so these are more possibilities I want to sketch that I hope the justices can discuss with us. So some things obviously are different that haven't changed in the past 10 years, right? So the United States relative indifference to international human rights framework isn't something that's new in 2022 or even in the past couple of years. The kind of relatively thin and austere ideas of rights in the United States, right? The idea that rights are primarily liberties from the government rather than any kind of guarantee that a right can be exercised, much less that a right could entail protections that were social or economic. Those, of course, are differences, but again, they're not new differences. some may even point to changes in religiosity in the United States, shifting more mirror, but that doesn't seem to be compelling either. If anything, at least Pew Forum would suggest that the United States has been secularizing in the past decade and a half or so, at a time when attacks on abortion, legal abortion in the United States have escalated. So I think there are a couple of changes that I would flag. One of them parallels something Alicia already mentioned, which is changes to legal education. In the United States, I think one of the things that made the Dobbs decision possible was that there's not, I think, a single legal community in the United States anymore. There are at least two. And that, of course, would soften any kind of reputational damage to the court that would come from undoing abortion rights, notwithstanding their pedigree in the legal academy and notwithstanding their popularity with the public. So changes to legal education are obviously part of that. Those changes have come, I think, in part through the courses that are taught, in part through, I think, the influence and legitimacy of the Federalist Society and the networks it's cultivated, not just in the judiciary, which is often where I think Americans are inclined to look, but more broadly, right, in law school communities and in classrooms, changes that I think made it possible for the court to feel that even if its decision would be derided in parts of the American legal world, it would be celebrated in others. I think changes to party politics in the United States are also pronounced. If you're looking for parallels to something like Dobbs, I think you would look, again, maybe to Brazil or to Poland. But the parallel to Brazil, I think, is interesting in part because it's a place where abortion has become very much enmeshed in party politics. It's become an issue, I think, on the right and to some extent, lesser extent, on the left, a way that politicians are able to win over voters who might not otherwise support them. And this shift, of course, emerged in the years after Roe, and I think has accelerated in recent years. This, of course, means that politicians nominating justices have an incentive to put not just abortion, but a particular vision of what abortion signifies front and center in the justices they choose and in the way they frame judicial confirmations. And we see, I think, this transformation very clearly in the United States. If you look in the 1970s, when justices like John Paul Stevens were being nominated to the court, they were asked no questions about abortion. And Roe v. Wade as a precedent was, I think, taken for granted by many Americans, including in the bar and bench. That, of course, was no longer true by the 1990s or certainly by the 2000s, when the fate of Roe was the elephant in the room in every Supreme Court confirmation. I think that was in part changes to party politics that made that possible, and those changes to party politics had knock-on effects when we think about how Supreme Court confirmation processes themselves changed. I think there have been changes too to attitudes for criminalization in the United States. I think both of the justices flagged that these were not just questions about abortion rights in the abstract that their courts faced. They were in part, I think, questions about the specific harms imposed by the criminalization of abortion. In the United States, I think in the same period, there's been far less suspicion of criminalization, notwithstanding recent campaigns against the growth of mass incarceration. In fact, I think criminalization as a solution gained ground in the United States in the decades after Roe v. Wade. Just for one example, between 1960 and 2000, the US prison population swelled by 600%. There were social movements that I think enhanced that idea, including the victims' rights movement, movements for the rights of law enforcement officers and others that framed criminalization not only as something that didn't violate rights, but that in fact enhanced rights. And the anti-abortion movement, I think, was able to successfully leverage that argument in Dobbs to suggest that criminal laws were far from constitutionally anathema. They were part of a deeply rooted history and tradition in the United States of sanctioning and even incarcerating wrongdoers in the name of protecting victims, including fetuses. I think all of this culminated in some ways in changes to the Supreme Court itself. So when I graduated from Harvard in 2007, I probably would never have believed that the court would have done what it did in Dobbs. That isn't to say I wouldn't have believed that the court would never overrule Roe v. Wade, but I think I would have thought that the court's relationship with popular politics, with social movements, with Congress, with perceptions of public attitudes, would have meant that the court would have proceeded in a cautious way, in a kind of incremental, stepwise fashion, as some of the justices mentioned,
to conserve its legitimacy, or at least reinforce the impression that the court is not a partisan institution, but a judicial one. I think within the judiciary and within party politics, norms about what legitimacy means to a court and how a court goes about conserving it have shifted in really fundamental ways too. And we can see this in the language of Dobbs itself. Justice Alito, in his majority opinion on doing abortion rights, flags the concerns about legitimacy raised by the dissent, which essentially mentioned the fact that the court had been unraveling abortion rights quickly, had been doing so at a time when there was no evident reason for the court to take up this case in particular. There was no split in the circuit courts. There was no urgency to resolve the constitutionality of 15-week abortion bans. There wasn't really even, properly speaking, from Mississippi, any pressing need at the beginning of the case to address the fate of Roe v. Wade. And so the idea of a court acting quickly and unnecessarily in the face of a change to its partisan composition, that was, I think, a concern to the dissent. But the majority said, instead, illegitimacy flows from the court, straying from its, depending on your point of view, its interpretive approach or its ideological norms, even when other democratic actors, including social movements, may desire that they do so. So the court, I think, itself has become, in some ways, more isolated from the kind of popular conversations that are happening around abortion, a truly kind of more counter-majoritarian court in the way that Alexander Bickel described in his famous book on the subject. So I think the story that both of the justices told you, I think, was a story about changes to democracy in Mexico and Colombia. And I think the same is true in the United States. If you're looking at how and why the United States is moving in another direction, it too is a story about changes to American democracy. So I'll stop there so we have time for Q&A.
Hello, thank you guys. My name is Brian, and just give me 45 seconds, just a little background, no diatribe. I can understand the moral grounds for outlawing abortion. It's not a trivial thing to have unprotected sex. You shouldn't do it just because it feels better. You'd better be prepared to raise a child. But that's getting a lot more expensive these days. My question is, in all your discussions with these legal changes, did the issue of declining birth rates ever come up? I don't think humanity will survive unless the birth rate falls dramatically. 10 billion by 2100 is too many.
Okay, so you've asked your question.
I just have just 15 seconds. 8 billion is too many. A sustainable number is probably 1 to 2 billion. But our economic growth has been predicated on cheap labor, and a declining birth rate would lead to a labor shortage and economic chaos. Having said that, economic chaos seems preferable to outright extinction of our species and millions of others.
Okay, would either of you like to take that? It's more of a comment than a question.
No, but I can say something. So there was a big discussion, not on the number of people in the world, but about people voluntarily having babies. Like, so there's a current discussion on unwanted pregnancy in Colombia, and basically one of the discussions on the abortion ban was that it was also preventing us to have a very broad conversation about sexual and reproductive rights. And so that is important because we have a really, really huge rate of teenage pregnancies, very, very huge rate even on forced marriages. That is a conversation that we're just currently having. So that was issues that came up at the discussion of the cases.
Quick answer, no.
Okay, go ahead. We're going to have to wrap up quickly, but just go ahead.
Okay, my name is Moses, and my question specifically goes to Professor Ziegler mentioned the effects that the Roe versus Wade decision had in the United States, and specifically the effect it had on the political system. So my question is, are you concerned that over the course of the next few years, and just like with Roe v. Wade, not immediately, there might be a public backlash to the decision that will lead to a lot of the things that we saw in the United States after Roe v. Wade, such as Supreme Court nominations founded on litmus tests, massive polarization, and a lot of the consequences that are sometimes attributed to Roe v. Wade?
Okay. Either of you? No, it's what she was mentioning has happened in the United States about changing the confirmation process for the court, making abortion a litmus test, aggravating political polarization.
Well, in the case of Mexico, it's always been when you're at a Senate confirmation, when you're at a Senate confirmation process, it's a political process. And the issue of abortion will come up. I will ask, and you politely answer that you can't give an opinion at this time because you have to wait for the appropriate case or controversy to come before court, and you can't anticipate any opinion on that. But yes, it comes up.
So for us, it's the same. The abortion issue is, I was nominated 3 times to the court, and so I had to go to the Senate 3 times and do the politics. But the abortion was not the key issue at stake when I was running. But it came out, and you'll always respond, I cannot talk about abortion at this time because if I get elected, I will be recused. But it was not such a big issue. In any case, I think what the American court has shown is definitely when the court composition shifts, precedents should not, but could shift as well. So there's.
Okay, if there are no more questions, I think we do have to wrap up. If the students who have pre-registered for the lunch with the justices, it will be next door. Before wrapping up, I want to really thank my colleagues at the Petrie-Flom Center who have been above and beyond incredibly wonderful in putting together this whole event. Glenn, who had to leave, and Carmel, and Laura, and Chloe, who does our communications. I want to thank all of you for coming, and Mary, who's now disappeared into the ether, very much. And most of all, I really want to thank the 2 justices who have been so generous with their time and sharing their insights from the inside about how this happens over time. So a big round of applause, and thank you.